Hello and welcome to Mayor Brown's Geographic Risk, Reshoring and Diversifying Your Supply Chain webinar. My name is Alex Dell and I am Head of the Banking and Finance Group of our London office, as well as co-chair of Mayor Brown's Supply Chain and Distribution Practice. Joining me today as co-presenters are Stephen Tran, Eugene Tay, Sydney Mintzer, and Michael Leibovitz. Stephen is a partner based in our Hong Kong office. He represents private equity, corporate and financial institution clients on their private equity, cross-border mergers and acquisitions, and joint venture transactions across a broad range of industry sectors. Eugene is a partner based in the Singapore office, and he is the head of Mayor Brown's International Arbitration in Asia. He specializes in international arbitration arising from a broad range of commercial disputes across a range of sectors including energy, natural resources, manufacturing, technology, construction and infrastructure, as well as hospitality and real estate. Sydney is a partner in our Washington, D.C. office. He specializes in government and global trade, representing clients in a variety of tariff proceedings, including ongoing Section 301 investigations. A licensed customs broker, he has assisted major US and foreign corporations involved in customs audits, focused assessments, and other proceedings before US Customs and Border Protection. Finally, Michael is a partner in our tax transactions and consulting practice in LA. He advises on tax aspects of international JVs, cross-border mergers and acquisitions, post-transaction integration, international corporate finance, capital markets transactions, and general international tax planning across multiple industries. Now, before we begin, I'd like to just mention a few housekeeping announcements. When you're accessing Mayor Brown webinars using our On24 platform, we do suggest avoiding the use of desktop virtualization software such as Citrix to decrease disruption or quality loss. If you have any questions, and you're very welcome to pose any, please feel free using the Q&A button on the screen. It's featured on the left-hand side, and we will do our very best to follow up with you as quickly as possible directly after the webinar has ended. Regarding CLE credit, we will be providing a code during the presentation. In order to receive the CLE credit, you need to record this code on the virtual sign-in sheet that was emailed to you with the login instructions for today's program. These forms are also available to download on the right-hand side of your screen under Resource List if you need them. And with that said, let's get started. So in 2020, we have seen massive supply chain disruptions arising from the pandemic. Added on to the supply chain disruptions caused by global trade tensions, cyber attacks, and digital transformation. In fact, supply chain issues have become front-page news, as you can see from the slide, and a topic of discussion amongst global leaders and the C-suite alike. For many, that's a surprise. However, we're guessing that for most of you on this call, it's a long overdue recognition of the increasing reliance of the world economy on supply chains, not just in goods, but also in services, technology, and data. Supply chain has gone from a back office function to a critical source of competitive advantage. We all yearn, I'm sure, for a return to the old normal, but according to a recent study by the McKinsey Global Institute, substantial risk and disruption is the new normal. McKinsey notes that in the past 20 years, the success of intricate production models has tripled global trade in intermediate goods, but it also predicts that companies will face major supply chain disruptions every 3.7 years. Rising volumes, rising complexity, and increasing disruption are all key risks that will require concerted work by business, technical, operational, supply chain, and other specialists. And the events of 2020 have shown that this to be a shared global challenge involving not just contracting companies, but also the governments that regulate and protect commerce, and the non-governmental organizations that set standards and align industries. And of course, supply chain and distribution lawyers have a vital role to play. Today, we as supply chain lawyers are called upon to go beyond helping clients to execute proven strategies for a predictable world, to being strategic advisors collaborating with clients to address novel issues. Here at Mayer Brown, our supply chain and distribution practice focuses on helping in the areas listed on this slide. As an example, a company that is pursuing a strategy of dual sourcing or reducing geographical concentration, which we're going to touch on in more detail, it may need to think of a number of things. It may need to build new contractual relationships. It may need to address the financial challenge of new suppliers, including through supply chain finance, manage disputes with existing suppliers, and prepare for supply chain disruptions. Critical legal and compliance issues may include customs, tariff, and other trade regulations, compliance and reputational risk, tax efficiency, IP rights and risks, and complying with antitrust and competition laws. And this is made possible by using AI platforms, online intermediaries, and other technology. And with that background, let's move to our specific topic for today. So I'm going to hand over to Steve in a moment. Steve, Asia is really standing at the epicenter of all the current activity in the reshoring and supply chain diversification space at the moment. And this is largely due, of course, to China's prominent role in the world's supply chain. From where you're sitting in Hong Kong, can you give us a brief overview of what you've been seeing in the reshoring and supply chain diversification landscape out in Asia to set the scene for the discussion ahead?
Thanks, Alex. And yeah, absolutely. There's been a lot of activity in Asia in this space recently. So I should start by saying, it's no secret that international companies with global manufacturing operations and global supply chains have really been looking for lower cost alternatives to China for years. So efforts by companies to reduce their reliance on China are certainly not new. But, as you correctly touched upon earlier, Alex, after 2 years of trade war tariffs, the massive disruption caused by the current pandemic, and just general anxiety about the deteriorating US-China relationship, there's been a noticeable uptick in international companies, particularly US companies, seeking to shift their China-based manufacturing operations elsewhere, as well as global buyers looking to pivot their supplier base away from China. So the pandemic has also caused some governments to rethink their dependence on China and other countries as well, but mostly China, as their principal source of critical goods. So everything from pharmaceuticals to food products, industrial equipment to advanced technology. And so governments out here and across the rest of the world are also now talking about reshoring. So who have been the greatest beneficiaries of these reshoring activities and supply chain pivot in Asia? Without question, the clear winner has been Southeast Asia. And within that region, Vietnam has definitely benefited most. Large companies like Apple, Samsung, Nintendo, and Fuji Xerox have already started moving fairly significant manufacturing capacity away from China to Vietnam. Across the border in Thailand, Sharp, for example, has relocated a large portion of its printer production lines from China to Thailand. And in Malaysia, we're seeing Sumitomo Rubber Industries, for example, shifting its rubber glove manufacturing operations from China to Malaysia. Bangladesh is the destination of choice for textile and apparel production, and Taiwan leads the way in the production of semiconductors and electronic components. Now, further east in Japan, the Japanese government has been particularly vocal lately about bringing manufacturing back onshore, with really the massive subsidies that they're offering Japanese companies to expand production back home in Japan, as well as in Southeast Asia. But it's not easy to make the move away from China. It's not at all like flipping a switch. There are certainly challenges. So, for example, on the manufacturing side, infrastructure issues can make it difficult finding suitable manufacturing facilities, and that's not to mention an adequate labour force in less developed countries to meet capacity needs. On the supplier side, finding an alternative supplier is always challenging, particularly at the moment when much of the world is still under some form of lockdown. And there are, frankly, very few markets that can even compete with China as a low-cost production site. You mentioned this before, Alex, but there are certainly tax implications. We'll touch upon this in more detail later on. And there are also contractual, intellectual property and enforcement risks. And again, we'll also discuss these issues in more detail shortly. And there are, of course, compliance risks as well. But, ultimately, the numbers need to be right in order to justify reshoring or redirecting supply chains to another country. Businesses make decisions based on economics. And so if the costs are too high to reshore manufacturing or to shift supply base, then it just won't happen. Back to you, Alex.
Thank you, Stephen. I think that's very interesting indeed. And I think to give some further colour on how difficult it might be to pivot away from China to other jurisdictions, I'd like to bring in Eugene at this point, because Eugene is a litigator, an international arbitration expert, and never mind costs and operational issues, that there's always the risk that you might end up in a dispute. And Eugene, you're in region as well. Are you currently seeing any evidence of an increase in supply chain disputes arising from these trends towards supply chain diversification?
Hi, thanks, Alex. Well, the short answer, and I'm sure listeners will be pleased to hear that, the short answer is fortunately no. Since the pandemic hit a few months ago, we have been busy across the disputes practice in Asia. And there has been an increase in disputes from particular sectors, especially energy, because of LNG and oil trading disputes, some frauds. But these are predominantly driven by sustained oil price collapse. Obviously, we've seen the retail, hospitality, leisure, transport sectors hit. These are largely because of the pandemic, and similarly construction and infrastructure. Some of these disputes are quite major and therefore they impact supply chains, but I would not describe these as having been caused by the theme we're discussing today, namely supply chain diversification. Having said that, for all the reasons you and Steve have mentioned, clearly there is a trend towards supply chain diversification. We do see an increase in inquiries. But I dare say these signs were there even before the US-China trade war and before the pandemic. What the trade war and pandemic have really done is accelerated efforts to diversify. And whereas that's the theory, everybody in short is thinking about diversification. It's something they have to do something about by a certain time. But like Steve says, it's not like flicking a switch. So every sector, every company will have different factors to think about, and these are the things we're going to discuss, Sid and Mike in particular. Southeast Asia does look like it's going to be a beneficiary of diversification away from China. But I think one of the key takeaways I'd like to share is there's one thing about being the clear second choice. It's another thing about that you're necessarily ready. We can't assume that these countries are necessarily ready for every single one of the companies that wants to diversify. Otherwise, that would have happened already and not have to be accelerated by these drivers. The thing about the second and third choice city is that they are second and third choice for a reason. They don't magically get better overnight just because you're suddenly under a constraint or an imperative to diversify. And here, I suppose, is where this issue of potential risks or disputes could arise. It's when there is some pressure to diversify and there is a rush to do so. At the risk of oversimplification, there are basically two types of disputes. The first would be linked to supply cutting. I don't have a more elegant phrase. Of course, I'm not suggesting that diversification necessarily entails exiting a country. What I mean is, in Alex's terms, a reduction in your geographical concentration, whether that means you end the JV arrangement or you cut down your supply or production commitments. And the second type of disputes is linked to the actual diversification. It's the act of moving your supply through to a new country. In the case of disputes arising from the first category, so from the exit or the downsizing, most companies will work very hard to avoid disputes, and they would do so successfully. But there are maybe a few issues that you'd like to think about in an exit. Three I can give as an example today. And first is to keep an eye on labor issues. Make sure that you're not faced with large-scale employee claims locally. To give an example, in China, most employees are hired under fixed employment contracts lasting 1 to 2 years. So if a company decides to close a factory in China, all local employees must normally be paid until the end of their fixed contract. And this can be a significant cost if the manufacturing operations being downsized are large. Second concerns your equipment, your tooling, your molds. Usually international manufacturers have to send expensive tools or molds to an OEM in China to make products. And these tools and molds are often worth hundreds of thousands of dollars each. If the international company doesn't take steps clearly to identify ownership of this equipment, there is always a risk that it may not see these tools or molds ever again after it exits. Chinese, and not only Chinese counterparties, but some Asian counterparties tend to consider that they have been given the equipment and that it forms part of the factory's assets. Sometimes the local government or the Chinese government may also be involved, and they may not allow the tools or molds to be exported. So if these sorts of issues are not anticipated and managed well, you could have a local issue to contend with. And the third concerns manufacturing IP or know-how. When an international company leaves China, it also tends to leave behind know-how in the sense that the Chinese counterparty has been taught confidential production methods. And although steps can be taken to protect IP in China, such as patents and brands, it's not as easy to protect a production method and the raw materials. So the international company may have taught the Chinese company how to make the product, and those methods could be used to produce the same product under a different local name that can be a competitor in the future. Now, the interesting thing is that these are not new risks or problems. These have happened before, because there was a first wave of supply chain diversification in Asia in the 90s, particularly when manufacturing and production shifted away from, say, Korea and Japan to China. So I remember cases from about 10 years ago where we were litigating for Western investors suing their former Northeast Asian partners for making use of their know-how to compete with them, sometimes or often more successfully, in new markets like China. In other words, we can expect the same to happen potentially this round. But in reality, I think most of the supply cutting types of disputes will be local, they would be fairly short-lived, and they'll be fairly easy to resolve. The larger disputes tend not to be about the exit itself. They do tend to arise from competition, as I've just mentioned. It's usually a fight over market share. In the case of the second category of disputes, and those entail entering a new market. And these types of disputes tend to arise because the investment is into a new territory with unfamiliar risks and lack of awareness of some of these risks. You would have, as Steve mentioned, you'd have new partners. You could have new workforce culture to contend with. You may be unfamiliar with local government. You could face lower standards of construction or production, variable quality standards, et cetera, et cetera. The obvious way to mitigate these risks is to do your due diligence properly and to study the market, but that's the theory. And as mentioned, this all takes time. So one of the reasons why companies would get into trouble is because they have to shortcut this process, because they're under pressure or under some kind of imperative to diversify. And in terms of a recent war story or maybe a horror story that I can share, there are many disputes that do arise from bad and rushed investment decisions. We've just completed a pair of ICC arbitrations in which a Northeast Asian client was under a lot of pressure to diversify its regional footprint and market share. So a directive was handed down by a very aggressive CEO who wanted to see a certain level of investment made in a certain Southeast Asian country by a certain time. No surprises, Steve mentioned that country was Vietnam. So the BD and M&A teams went out. They were desperate to find a suitable business spouse This is quite a specialized sector, so in Vietnam, there weren't many contenders of the right size who were even interested in the first place. But the investor was so desperate that they found someone and they forced it through. Sadly, everything that could go wrong went wrong. The choice of partner was bad. There were misrepresentations that hadn't been picked up. There were mistakes made in structuring. Local laws were not properly understood. The local market itself was unfamiliar, and they were too dependent on the local partner who turned out to be dishonest. The investors' management team on the ground was outsmarted by the locals, and ultimately the investment failed and they were cheated badly. And this also affected their reputation and hindered their ability to find a new replacement partner, even though they're a well-known and solid brand. It ultimately resulted in 2 large arbitrations, a whole series of local litigation. And in retrospect, the mistake that was made was simply a rush decision to make an investment. Hopefully, we're not going to see this happening too much as far as supply chain diversification is concerned, but there will be some of these types of cases. I think Southeast Asia is a very good place to look, but choose your countries wisely. It's easy to focus on similarities between ASEAN countries and downplay their considerable differences. So Vietnam, Thailand, and Indonesia can look similar in many ways, but they're actually very, very different. Similarly, Malaysia and Singapore are similar in many respects, but again, very different. Taiwan and China are similar, but very different. India, Bangladesh, again, similar, but very different. I don't think the Chinese government's self-confidence is a bluff, and I don't personally see massive factory moves out of China all at the same time. I do think there will be a gradual shift, most definitely. But even Chinese companies themselves are looking to make such a shift over time because their domestic costs are going up. With that, I hope this has been helpful. Back to you, Sid.
Great. Well, thank you very much. As we move on to the next slide, we've heard a lot about moving from China and trying to figure out what has to be done in order to try to mitigate risk. As a trade and customs lawyer, I've been hearing for years now that costs in China were increasing, labor costs in particular, and that moving production to Southeast Asia was in play. But I don't think anything has ratcheted up the risk to global supply chains more than the current U.S.-China trade tension, especially for those companies that depend at all on U.S. suppliers or the U.S. market. The Trump administration's stated policy is to decouple the U.S. from China, and it's attempted to do so with 3 sort of broad-based tools. One, duties on imports from China into the United States. Second, restrictions on U.S. exports of goods and technology to Chinese entities and to customers in China. And increasingly, enhancing enforcement of U.S. forced labor laws, which prohibit the importation of goods produced with forced labor into the United States. I think a lot of companies looking at the upcoming U.S. election may see 2 diametrically opposed candidates, and I certainly think that's, as a layperson, certainly it would be reasonable to see that. But on trade, it's a little more complicated. The progressive wing of the Democratic Party and the populist wing of the Republican Party on trade have a good deal in common. And while a Biden administration might project a different tone, his team has already commented that tariffs would continue to be used as a policy lever. Therefore, I think it's reasonable to assume that the continuation of what we call 301 tariffs, which are these very high, almost punitive duties on imports of Chinese products into the United States, they're a good bet to continue in the intermediate term. I think the re-engagement of our forced labor laws, which really started right at the end of the Obama administration, but has ratcheted up under the current administration, will continue to be used as an important lever, particularly with respect to China. We've seen a dramatic increase in the number of customs investigations targeting forced labor. These usually come in as allegations made to customs that products are, with reasonable suspicion, produced with forced labor. We've seen them targeting industries and countries around the world, but China has certainly become at the center of the discussion, and indeed there's a move in the Congress, a bipartisan move in the Congress today, to instruct customs to investigate any products produced with cotton from the Xinjiang region of China, which is a very broad base, which would be a very, very broad investigation if it ultimately comes to pass in the United States. One change I think we may see with a Biden administration, should that come to pass, is that he and his folks have already criticized the president on its approach to traditional U.S. allies in Europe and Asia. And so, as some of you may know, we have a separate set of duties that the Trump administration imposed on steel and aluminum products from around the world. And so it wouldn't be as surprising to see those duties perhaps mitigate over time. And as a general matter, perhaps greater reliance on diplomacy and multilateral or bilateral efforts to calm down trade tensions outside of the China context. Next slide, please. So all that leads to a basic question for a global supply chain. How do you transition from China? And what does it mean to be a Chinese good? At the border, U.S. Customs requires importers to declare a country of origin, which is true of any customs authority in any country of the world. And the problem is that since really the imposition of new duties in 2018 on Chinese products, Chinese origin inevitably leads to higher costs and also heightened scrutiny. And what a Chinese product isn't a complicated question if you import vegetables grown in China, or even vertically integrated steel producers that produce steel from ore mined in China. Under U.S. law, both would be clearly Chinese origin. Really, the complexities arise when a complex manufacturing operation sources inputs from multiple countries with perhaps predominant manufacturing in China, perhaps even downstream processing in a third country. And the question arises, what is the origin of that good? And in the United States, country of origin is determined by utilizing what's called the substantial transformation test. And the main question underpinning the test is, where has merchandise been substantially transformed? And as it sounds, it's a qualitative test. I think what can be frustrating is that there's no hard answer to what does it mean to be substantially transformed. It really is, under U.S. law, balancing test. And it's a balancing test that has evolved over time, especially given that the United States is a common law system. So Customs has given its opinions on the meaning of substantial transformation, particularly in specific instances related to particular products or supply chains. And then the courts have also established rules of the road. All that means it can be difficult to apply when you're you're applying it to a greenfield issue, meaning an issue that for a product or for a supply chain that hasn't really occurred in the past. So what are the main considerations when considering the substantial transformation test? Certainly the courts and customs look at the manufacturing activities in the exporting country. They're looking at where costs are incurred and for what. So if you have an assembly operation in China, but all of the inputs are sourced outside of China, if the assembly operation is minor, then just the mere fact that that article is exported from China will not necessarily mean it's of Chinese origin. The question will be which input imparts the primary character of the ultimate article. So, for example, an issue we dealt with last year was high-end bicycles, which were ultimately of produced inputs and parts were produced in China, but they were ultimately assembled in Taiwan, and they even included very high-end gears and braking systems from Japan. And the ultimate question was, well, is this Chinese origin? And at least for our client, the news wasn't great because U.S. Customs has determined that wherever the bike frame comes from, the part that the main part of the frame, wherever that comes from, is the origin of the bike, regardless of anything else. And that's true even if the frame isn't the majority of the cost of the bike, which in that case it was not. So looking at a very complex fact pattern, you can sometimes be surprised as to what the result is. In some cases, as I said, precedent has developed around certain articles. So chemicals, for example, are of origin in the country where a chemical reaction occurs that produces the finished good. So if you're a chemist, or as a lawyer, I'm not a chemist, so if I ask a chemist, here are the raw materials of this chemical, when does the primary chemical reaction occur? And he or she will tell me, and then I can figure out where in the supply chain the origin of that product is. But the application of the law is, as I said, often is case by case and does create uncertainty. And mitigating that uncertainty is possible, although it requires some planning as well. You can certainly submit requests to U.S. Customs for rulings on products. They're not necessarily simple submissions. They can look very much like a mini brief with arguments, relying on court cases to make points. And they take time to prepare and submit and ultimately resolve by the authority. So risk is certainly possible to mitigate, but it does take some planning. So with that, I'm going to kick it back to Alex.
I think that's great. I've got a couple of questions for you, if that's okay. So you mentioned that the US uses a balancing test to determine origin, but are there any safe harbors? And is there a certain level of cost or value that could be generated outside of China that will ensure a change in origin for a particular good?
It's the question that I'm asked most often by every client, and especially in the last couple of years as these special duties have been imposed on Chinese articles. Most clients don't want to shift, especially if they're producing in China and they rely on Chinese raw materials. They're invested in China. It's hard to just move completely. So what they want to know is, well, what do I need to move to another country in order to change the origin of my product under U.S. law? And it's impossible to give a specific cost or value component because sometimes that factor isn't even the primary one considered by customs. And I guess a vignette is probably easiest to explain. We had assisted a client last year that was, they produced a high-end consumer electronics product, and it was sourced, not only were the raw materials, motherboards, PCBAs, all the major components of this article were produced in China, but it was ultimately assembled in China and exported, clearly Chinese origin upon entry into the United States. And the question to us was, what do we need to do? How can we parse out our supply chain in a way that is both efficient to us as a business, but also allows us to transform the product into another country of origin? And what we were ultimately able to develop facts and make arguments to U.S. Customs that ultimately the products, the essential character of the product was actually the brains of the product, which for customs purposes, that was the PCBAs. So we were able to transform their supply chain by moving PCBA production to a third country, and virtually everything else was able to remain the same. And even though the PCBAs did not account for the majority of costs of the finished article, Customs agreed with us that at the end of the day, the PCBAs formed the essential character of the product. And therefore, as the essential character of the product, where those were produced were the origin. So today, product imported from China is now declared country of origin of this third country, and they're able to legally avoid the special Chinese duties in place. But again, it was really there was no safe harbor. It was all based on legal argument, precedent, and balancing the various factors.
That's great, and I've got one more for you, Sydney, if it's okay. So the U.S. law governing origin seems complicated. I'd agree with that. Are the rules in other countries the same? A lot of our listeners today probably export around the world, so it's just a pertinent question. Thanks.
Yeah, thanks, Alex. They're not. I mean, the U.S. is somewhat unique here. And I think, it relates to your prior question, because a lot of countries, a lot of agreements, bilateral free trade agreements, multilateral trade agreements, and even just general trade between parties look at specific, they rely on third parties to determine origin. So, for example, if you're exporting from Vietnam to Malaysia, a Vietnamese producer might go to a local authority that's authorized to analyze a product and determine its origin. And once you get that certificate of origin, it's Vietnamese product, and that's going to be respected upon entry into a third country. But that's just not true in the United States. Though indeed, I've worked with clients who insist, indeed just last year or earlier this year, a client was importing product that had a Vietnamese origin certificate, and it was relied on upon entry into the United States. And indeed, it may have been Vietnamese origin if it were entering other countries, but into the United States, that certificate meant nothing. And indeed, the product was ultimately determined to be Chinese origin. So if you are used to exporting to other countries and relying on different regime, you do have to reorient yourself when you're thinking about the U.S. because the system is just really different.
That's great, Sydney. We're going to move on to our final contributor today, Michael Leibovitz. Michael, as you know, is a tax partner in our LA office, and he's a specialist in cross-border tax issues. And I guess what we're hearing today, that it's sort of easier said than done to decide that you want to be less reliant on China, as a primary source of supply and wish to pivot away perhaps to other jurisdictions in region, or reshoring back to the US. Tax considerations are, however, never far away from understanding what may be involved from realizing that narrative. And Mike, I'm sure, is going to enlighten us on some of the tax issues that should form part of your thinking. Over to you, Mike.
Great. Thanks, Alex. And yes, with respect to tax, it is easier said than done, and we'll touch on a number of issues with respect to that. So with respect to tax, there's really three questions. Where do you go? Where do you reshore? Can you leave the country? Can you move your supply chain without material tax costs in the country you're leaving? And given that we have a number of U.S. attendees here, is the U.S. a tax-efficient option for reshoring? Is it appropriate, at least from a tax standpoint, to bring supply chain back to the United States? So next slide, please. So first question, where do you reshore? And this question is based on a number of considerations, some of which won't be surprising to many of you. Driven in part by a low corporate income tax rate, and we see competition around the world with respect to low corporate income tax rates to attract investment. Further, are there tax incentives for bringing manufacturing or other activities to that country? Tax incentives in the form of a very low tax rate or a zero corporate tax rate for a period of time to bring manufacturing or other activities to that country. Singapore, it had, for a long time was the poster child for this, and that's why a number of in the 70s, 80s, a number of companies went to Singapore because Singapore was very aggressive at bringing manufacturing, distribution, IP related, R&D related activities to Singapore in return for a zero or very low corporate tax rate. Importantly, in this, Singapore was viewed as a very stable tax regime. The stability of a local tax regime is as important as a low corporate tax rate. Multinationals are happy to invest where there is a low corporate rate or there are incentives, but as important is the stability of that regime. And is the regime changing? Is the incentive regime inherently unstable? Is the political environment unstable in that country such that tax laws continue to change? How expensive it is or inexpensive is it to repatriate profit from that country? You may have a low corporate tax rate, but it's expensive from a withholding tax standpoint or other factors to get the profit out of that country. And then, as important and increasingly important is, can you retain those tax efficiencies in your home country? And we'll touch on this when we get to the U.S. Discussion. But many countries around the world now have controlled foreign corporation rules, and which will impose a home country tax on foreign country profits. And so even though the local country has a low corporate tax rate or a zero corporate tax rate, you're going to pay tax in your home country in any event. Then the benefit of a low corporate tax rate in the manufacturing or distribution country really is meaningless. And this is, one of the key developments that's happening on a global tax level, is that there are changes brewing around the world where home countries will start taxing low tax profits. And so that's an important component, and we'll touch on this in a few minutes when we talk about the U.S. So let's move to the next slide.
Mike, before we do that, do you see much competition between countries to attract business leaving China?
Absolutely. And Steve has already mentioned Vietnam and some of the other countries in Southeast Asia. You see this around the world where countries are using tax as a way to encourage investment. And historically, countries were sort of free to do that as they saw fit. Now, with the advent of some of the changes in connection with the OECD's base erosion and profit shifting projects, there are limitations on that. And so countries can use their tax rates to attract investment, but there are limits to what increasingly there are limits to what a country will be able to do and still be consistent with international standards for taxation. And so you're still seeing this competition, but countries are less able to, countries are now more required to tie their tax rate to actual real investment in their country in order to grant incentives. So if you're going to grant a low tax rate for manufacturing, the manufacturing in that country needs to be significant, not only to enable the tax incentive to be respected in that country, but also to be respected by other countries. So you could have a very low tax rate for manufacturing, but if a third country doesn't respect the level of substance that you have in that country, in the country of manufacturing, a third country might try to tax that layer of profit as well. And so what you're seeing is a global review of marrying substance with tax rates and ensuring that the profit that has come to rest in a particular country matches the substance in that country. So with that, let's turn to we've talked about where do you go. Let's talk about can you leave, and how easy is it to just pick up and move your supply chain from a tax standpoint. And the short answer, from a tax standpoint, and we've heard this elsewhere in the discussion already, is it's not that easy to do. There are significant tax consequences when you're changing a supply chain structure. Most countries will seek to impose some sort of an exit tax when you move a supply chain, and they'll try to tax what's viewed as a deemed transfer of the goodwill. So you could easily see, it's understandable if you're moving equipment, if you're moving tangible goods, and those goods are leaving the country. You could see countries want to tax that, but there's also value, there's also goodwill associated with that supply chain. And when a supply chain moves, that goodwill is moving somewhere else. And so most countries will try to tax that on some basis. And this is a very well-developed concept in Europe, and it arose. There was a similar tax competition trend that happened in Europe as companies were moving from higher tax countries, Germany, France, Italy, moving to Poland, Romania, Czech Republic, Slovakia, and Germany, France, Italy said, look, you can leave, but that's an implied movement of goodwill, and so we're going to tax you on that. This is a very well-known concept. we expect China to impose, similar taxation as supply chains move to other countries. It would be very easy to see China impose some sort of an exit tax, some sort of tax as supply chains move from China to Vietnam. You can expect that China is going to try to tax that, and that's problematic enough. But if the home country doesn't recognize that deemed transfer of goodwill for one reason or another, then you could be in a position where you're having a local tax without the ability to credit that tax in your home country. And so there are significant challenges when you're leaving. In the U.S., we often refer to this as the Hotel California effect. And those of you who are fans of the Eagles will know that in Hotel California, you can check out anytime you like, but you can never leave. And that's the tax. That's the tax cost of trying to get out of a country. So I'd like to move to the next slide. And so, is the U.S. a real option here? There's been a lot of political toing and froing on whether the U.S. whether multinationals should bring their manufacturing and supply chains back to the U.S. And with our 2017 tax reform, there were incentives built into the system to try to bring manufacturing and supply chains back to the U.S. We dramatically lowered our corporate rate from 35 to 21. And we added an incentive to encourage, an incentive referred to as a foreign-derived intangible income incentive, to encourage companies to manufacture in the U.S. and export outside the United States. And so those are two significant incentives that were designed to bring manufacturing and supply chain back to the U.S. At the same time, we created disincentives to discourage offshoring of manufacturing. In 2017, we immediately taxed the upwards of $2 to $4 trillion of accumulated offshore profits. We had a one-time tax. And at the same time, we created a minimum tax structure on future offshore profits. So this touches on the comment I made earlier that, a country may have a very low tax rate for manufacturing, but if the U.S. is going to tax that profit anyway, then the benefit of a zero or low foreign income tax rate is not as significant if the U.S. is going to tax it anyway. And on top of that, we added an additional minimum tax when U.S. companies are making deductible payments to foreign-related parties. So the combination of our low corporate rate, our foreign-derived intangible income incentive, coupled with these disincentives, were designed to try to move manufacturing back to the United States and keep manufacturing into the U.S. And so that has had, moving to the next slide, that has had some effect on bringing manufacturing back to the United States. We'd be remiss if we didn't talk about what might happen under a Biden administration. And Biden has already announced a couple of plans to further encourage reshoring and further disincentivize offshoring. The first is a proposed 10% surcharge on round tripping. So this is the paradigm where a U.S. multinational manufactures outside the United States to resell product back into the United States. And so there'll be an additional 10% surcharge on that. Coupled with that is a new 10% tax credit for new investment in U.S. manufacturing and jobs. And so again, this mirrors the 2017 tax reform where there's a carrot and a stick approach here designed to try to bring U.S. companies back to the U.S. and keep them here. Now, interestingly, with respect to this 10% credit for new investment, the U.S. is a member of the World Trade Organization, and as such, we are obligated to comply with WTO standards. It's an open question whether that 10% credit is compliant with our WTO obligations, similar to the foreign-derived intangible income incentive I mentioned earlier. And so you could have a scenario where, as a result of the incentives to bring, the incentives that I've mentioned to bring manufacturing back to the United States, you could have companies bring manufacturing back and have these incentives ruled non-compliant with the WTO, and so that has the inherent instability of the U.S. political system and the potential WTO challenge to export incentives. Will give U.S. multinationals pause before they decide to bring manufacturing back to the United States. And so decision making is increasingly challenging in an unstable environment. And that, stability, as I mentioned at the outset, is what drives, at least from a tax standpoint, decision making by multinationals.
That's great. Mike, thank you so much. We're running out of time, and we've got a bunch of questions that have come in, which is great. And there's just one that I'm just gonna pick up because I think we've got time, and this one's for Sydney. This is from Yoko Uenama, and I do apologize for the mispronunciation. But the question is, usually we use value-added criteria or change in tariff classification criteria to determine the country of origin. Why only the US takes the different criteria? So Sydney, one for you.
Sure. So customs law is dictated in part by international rules governed by the WTO and in part by local jurisdictions. So how the U.S. applies country of origin rules is really a local law question. The issue, one thing to keep in mind, however, is when you're thinking about whether a product is Chinese origin, you look at the standard substantial transformation test I described earlier. However, the U.S. obviously has entered into many bilateral and multilateral trade agreements, and those trade agreements, those free trade agreements, inevitably provide more rigid rules on whether a product is, let's say, Japanese or U.S. origin for purposes of a bilateral FTA like the U.S.-Japan FTA. So those rules typically are governed by what we call tariff shift, which means a change in tariff classification, or particular value requirements. So if you're governed by a free trade agreement, the rules are more clear. If you're just being governed by U.S. common law when considering a country like China, which is not under a free trade agreement, then the less transparent rules, the balancing test does apply.
Thank you very much, Sydney. That's fantastic. And that concludes today's webinar. I, on behalf of all the speakers, hope very much that the information today that was shared was useful to you. For those who posed questions that we didn't manage to come to, we will come back to you very shortly after this. Thank you very much for your participation today, and have a great day.